Ladies and gentlemen, may I have your attention, please?
Covering both sides of the big issues with the analysis you trust on NewsRadio 1040 WHO.
A majority of small businesses are not requiring their employees to get tested for the new coronavirus or get any COVID-19 vaccines. Now, this won't surprise you. There's exceptions to that in the healthcare and hospitality industries. But with some employers requiring it, some employers not, what are your rights as an employee? Well, attorney Quentin Brogdon is one of my go-to people to talk to about these issues. And Quentin, welcome back to the Newsmaker line. As a worker, what rights do I have, and are those rights affected by what industry I happen to be in? What do you think?
Hello, Jeff. Good to talk to you again. You're right. Most employers are not requiring negative COVID tests for their employees, but some are, particularly in high-risk areas, hospitals, nursing homes, assisted living, places like that. Normally, a COVID test would be what's considered a, quote, medical examination under the Americans with Disabilities Act, and the circumstances in which an employer can require a medical examination are very, very limited. But the EEOC, the Federal Equal Employment Opportunity Commission, has said that under the circumstances of this pandemic, employers may require that their employees be tested. So there is the ability legally for employers to do that, barring, medical conditions or things of that nature. In fact, employers probably can require employees to be vaccinated. During this pandemic, the employers are being given a lot more latitude than they normally would have under the law to violate essentially the privacy of their employees and impose requirements. So particularly if those employees are in high-risk jobs, again, hospitals, nursing homes, employers are on pretty firm ground in requiring vaccinations with only limited circumstances. If the employee has a sincerely held religious belief against being vaccinated, or under the Americans with Disabilities Act, if the employee has some kind of disability that would make them more susceptible to the bad side effects, then the employer has to make a reasonable accommodation. But barring that, employers are being given a whole lot of power right now over their employees.
And Quentin, that is a key point for me. As you said, a whole lot of power right now, that they're being given a lot of latitude. And that really has been a theme during the pandemic. It's an emergency. It's a national emergency. It, of course, was declared a health emergency here in Iowa. So a lot of powers were granted to folks that they normally don't have. Do you think there's a time limit that at some point employees will have a right to say to an employer, okay, you just don't have this kind of power? Like you said, we get into the tricky area of healthcare law, healthcare privacy, the Americans with Disabilities Act. Is there a time limit to employers being given this kind of latitude?
Jeff, I sure hope there is a time limit. I hope that this, pandemic is in the rearview mirror, at least by the end of this year, to the extent that the government and others start issuing guidance that says, the emergency has now passed, and this leeway that we've granted employers, hopefully only on a temporary basis, we're now rolling that back. That's the hope. We don't want these kinds of invasions of privacy and requirements to have to become permanent. I don't think anybody wants that. So hopefully that's what we're going to be looking at, is a rollback of this by the end of the year, no later than then, I would hope.
But not to be a pessimist about it, Quentin, but I could see employers going, boy, I really like being able to try to keep my employees healthy. It's good for my bottom line. It's good for productivity. Do you anticipate that there's going to be some challenges at some point because some employers really like having this kind of power?
Sure, absolutely. I think we're seeing some of these, legal matters play out in real time, and some of these rules literally are being made up as we go along. We're getting some guidance from the EEOC and others, but, the hope is that the guidance will change. And as long as there's guidance out there saying employers can do certain things, it's harder for an employee to argue it's unreasonable or it's not sanctioned in some way, not allowed. But once that guidance changes, which I anticipate and others anticipate will happen, then it's going to be much easier for an employee to say, well, the EEOC is no longer saying I can be tested, or employees generally can be tested unless they're in high risk or some other exception. Therefore, this is an unwarranted invasion of my privacy, and it violates various statutes or regulations.
That is attorney Quentin Brogdon, and that is great insight on a really important topic. Quentin, it's always a pleasure to talk with you. Thanks very much.